Good morning, and thank you for joining us. Yeah, I hope you got more sleep than I did. I'm very honored to be here today with Mr. Wells, Chair of the Statutory Review Committee, and with committee member Mr. Doug Leto as well. Last year, government formed this committee and gave it a mandate to undertake an independent and comprehensive review of the Access to Information and Protection of Privacy Act, including the amendments made in 2012 as a result of Bill 29. When drafting the terms of reference for the review committee in 2014, the government of Newfoundland and Labrador made an unqualified statement that the work of the review committee would be open, comprehensive, and independent, and would engage citizens and stakeholders in a meaningful way. In selecting the committee, we sought individuals with expertise in law, with expertise in privacy legislation, and with expertise in journalism. The committee included Clyde Wells as chair, Jennifer Stoddart, and Doug Leto. Mr. Wells is a lawyer, former Chief Justice, and a former Premier of Newfoundland and Labrador. Ms. Stoddart is a former Privacy Commissioner of Canada, and Mr. Leto is a journalist with over 30 years of experience. We were so fortunate to have such highly qualified and respected individuals in their chosen professions agree to lead this important review. Individuals of this caliber were sought out because our government wanted our legislation to be the best in Canada and among the best in the world. We wanted to lead the world in access to information and protection of privacy, and I really believe after reviewing this report that we will achieve that. Mr. Wells and his committee have been working diligently over the past number of months, calling on the public and community stakeholders to make written or in-person submissions, and inviting ATIPPA coordinators to provide feedback through anonymous questionnaires. The committee also conducted a jurisdictional review of practices across the country and around the world. The overarching goal of the committee was to complete a meaningful review and achieve a strong framework to support access to information and protection of privacy in this province that would serve as a model for other jurisdictions. The scope of work for the committee was broad and included identifying ways of making the legislation more user-friendly, assessing the right of access, examining the powers and duties of the Information and Privacy Commissioner, as well as considering time limits for responses to access to information requests and fees for handling requests. Today, with the release of their final report and recommendations, the committee has achieved those very goals. The committee has made valuable recommendations respecting the changes in the legislation they think are necessary. Legislation that, when compared with international standards, will be user-friendly and rank among the best in the world. On his first day in office in 2009, U.S. President Barack Obama stated that all agencies should use modern technology to inform citizens about what is known and done by their government. Disclosure should be timely. The provincial government believes that people have a right to access government information, with some limited exceptions, and we want to ensure that our legislation supports this very principle. Addressing this principle is exactly why we began the independent review of our access to information and protection of privacy legislation even sooner than the 5-year time frame required by law. It is also why government committed last year to joining other jurisdictions in Canada and governments around the world in increasing transparency and accountability through this province's Open Government Initiative. Ultimately, we believe in the principle of opening up government to those who own it, the people of Newfoundland and Labrador. In this spirit of openness, our government is excited to be moving forward, and as Premier Davis has made very clear, we will be acting on the recommendations contained within the Review Committee's report. We know there's a great deal of public interest in this review and the recommendations put forward by the committee, and we've already begun a comprehensive analysis of this report to allow us to respond quickly to these recommendations. Through this report, the Review Committee has created an innovative, user-friendly framework that will assist municipalities, clarify the role of the Privacy Commissioner, strengthen the work of the ATIPPA coordinators, and modernize the way government provides information to the public. It's worth noting that the committee reviewed not only those amendments in 2012 that were contained in Bill 29, but all aspects of the legislation. This will lead to a stronger piece of legislation, a brand new piece of legislation overall. This comprehensive review of our ATIPPA legislation, policy, and practice far surpassed the narrow focus on amendments that we made in 2012. The committee's work allows us to have a stronger piece of legislation, better defined roles, and more progressive policies and procedures. Their proposed legislation will rival any in the world and make us a leading jurisdiction in access to information and protection of privacy. The Office of Public Engagement has started an analysis of the report to assess the impacts of the recommendations on financial resources, human resources, on other legislation and government processes with a view to clearing the path for implementation. What will be put in place through this legislation will be world-class, and it will set the bar extremely high for access to information and privacy protection. It truly is a made in Newfoundland and Labrador solution, crafted by experts and drawing on the best ideas in the world. On behalf of Premier Davis and the Government of Newfoundland and Labrador, I thank Mr. Wells and Mr. Leto and Ms. Stoddart, their office staff, and everybody else involved in the valuable work they've carried out, aimed at strengthening access to information and protection of privacy in Newfoundland and Labrador. With such a distinguished and learned committee and support team, the people of the province can have full confidence that this review was conducted in a thorough manner. I want to thank you all for joining us today. I know we have government MHAs, opposition MHAs, representatives of the media. I know our Information and Privacy Commissioner and members of his staff are here. Thank you all for joining us. I will now invite Mr. Wells to speak to some of the details of the report. Mr. Wells.
Thank you very much. Just before I do, Minister, I would like to draw your attention to the obvious fact that Ms. Stoddart is not sitting here with us. She would have been here, but she had another commitment in Washington, D.C. today and couldn't be here. But I want to particularly acknowledge the very important and specialized contribution that she made to the committee's work. As a former Privacy Commissioner for Canada, of course, she had great knowledge and great experience and contributed greatly to the work of the committee. And I don't want her absence to be misconstrued in any way. I want to acknowledge the terrific contribution that she made. Now, in responding to the Minister's suggestion, I'm quite prepared to go over and summarize each of the sections fairly quickly so as not to take up all your time, or if you'd prefer, I'd answer questions. I'm going to assume, unless the media tell me otherwise, that you'd prefer me to do a quick summary. Okay, the introduction is a bit lengthy, but it's important because it explains in detail how the committee interpreted its mandate and why we interpreted it in the manner in which we did. So it will be a good guide to you for understanding the approach that the committee took to its work. I commend it to you. Before you read the report, I commend reading the introduction for that reason. Chapter 1 deals with the stature of the right to access information and the right to have your personal information and privacy protected. We felt that this was necessary in order for us to put the protection of these rights in proper context. You can't very well provide for the proper procedures for the exercising of those rights without having it in the context of others. The rights are not absolute, as most people will recognize. There are some justifiable limitations on those rights, and we've provided for them. But with respect to the stature, you will find in the first recommendation on page 39 of the report, sets out the purpose of the Act and the manner in which we recommend that the objectives of the Act be provided for in legislation. I don't need to go into detail. I'll answer any questions, or Mr. Leto will answer any questions you may have, but I don't want to take excessive time dealing with matters that you may not be particularly interested in. Chapter 2 is an assessment of the existing procedures that are in place and how the ATIPPA coordinators in the various public bodies function and the procedures that they've been employing. They've been guided in the main by guidelines that have been prepared by the office, the OPE, and the guidelines that we saw, the manuals that we saw, were quite well done and would be very helpful for anybody seeking to use the Access to Information Office to be guided by those. We made recommendations with respect to fees and charges And those recommendations are to be found on page 58. We recommended that the basic application fee be abolished. We don't think it serves any great purpose. It's not, at $5, it's not such as would deter anybody from making a request that ought not to have been made. And at $5, it only costs government a good deal more dollars to administer the collection of it. So it seemed a pointless fee, and we've recommended that it be abolished. We've also recommended that there be an increase in the amount of free time before charges for searching are made, such that public bodies other than municipalities should provide 15 hours of free time, and municipalities would be expected to provide 10 hours of free time. We've also noted in that chapter that the practice of public bodies being able to disregard requests be discontinued unless they have the prior approval of the commissioner, so that public bodies would not be able to unilaterally decide to disregard requests. Chapter 3 deals with a couple of important matters. The public interest override. We've made recommendations for significantly expanding the public interest override. You will find that in recommendation 10 on page 279. It applies to many more areas than it had applied to in the past. And it simply recognizes that in the end, the public interest is what's important, the broader public interest. That chapter also deals with a variety of exemptions, including exemptions that were put in place as a result of Bill 29. For example, the exemption for access to ministerial briefing records. Those exemptions were added by subsections 4, 5, and 6 of Section 7, and we've recommended that they be repealed and the exemption be eliminated. It also deals with cabinet confidences, including a suggestion that we had from one presenter at an early stage, and he suggested that it's important for a better understanding by the public. It would be important for the committee to do an assessment of the historical background and significance of the cabinet confidences exemption to public access. And we adopted his suggestion, and we did that kind of assessment, and it's to be found in Chapter 3. Chapter 3 also covers others, policy matters and other exemptions that were put in place as a result of Bill 29. We deal with the question of incomplete reports, or designating a report as incomplete and as a result being able to refuse to release it. We've now suggested that, and this raised doubts about the integrity of the system, because people viewed it as government or public bodies being able to simply declare a report as incomplete and therefore refuse to release it for a 3-year period. So what we've suggested to accommodate both the fact that some reports are indeed incomplete, and to give the system a better integrity and a better perception of integrity, we've provided that no such report can be deemed to be incomplete unless within 65 working days, that is three months, within 65 working days, the agency that received the report requested further review on it, designated it within that time frame as being incomplete. If they didn't designate it as being incomplete within that time frame, they could not later call it an incomplete report. And this should eliminate the bad perception problem that existed before. We also dealt with policy advice, dealt with solicitor-client privilege documents, and the provision in the legislation put in place as a result of Bill 29 that prevented the commissioner from seeing solicitor-client privilege documents, and so being able to express an independent opinion as to whether or not they were in fact solicitor-client privilege documents. The committee heard during the course of its hearings that in some cases, public bodies simply declared them to be solicitor-client privilege for the purpose of preventing disclosure. Well, that can no longer occur. The commissioner will be able to look at any solicitor-client, any document claimed to be solicitor-client privileged. Nevertheless, the privilege is very important to society, and the committee explained its level of importance by relying on decisions of the Supreme Court of Canada on the issue. And the procedures that we've recommended and put in place, we feel will provide an appropriate level of protection for documents that are genuinely solicitor-client privileged, but at the same time ensure the integrity of the system by providing the commissioner with a means of accessing the documents so that the commissioner can consider them. In that same area, we also dealt with the related business of third parties. You will recall that Bill 29 altered the test. Prior to Bill 29, in order to be entitled to exemption from disclosure, a third-party business document had to demonstrate 3 critical factors. Bill 29 provided that if they demonstrated any one of the 3, it could be designated exempt. Well, we've recommended repeal of the provisions that Bill 29 put in place, so it's back to the original 3-part test. Chapter 4 deals with records to which the ATIPPA does not apply. And that's set out in Section 5 of the Act, which lists some 14 types of records, not specific records, but types or classes of records that should be exempt. And there are a variety of things listed there, including judges' notes, quasi-judicial decisions and notes, political files, and so on. The commissioner had never been able to gain access to it. He challenged it 3 times in the court, and each time the court concluded that because the legislation provided that the Act did not apply to such types of documents, the commissioner could have no power because his power arose solely under the Act. That issue is still before the Court of Appeal, so we were careful not to express a view as to what that decision should be, but we felt no compunction against expressing a view as to what provisions of the legislation ought to be in the future. And while we recognize that there were maybe a half a dozen of those classes of documents that clearly ought not to be accessible by the commissioner, police investigations, prosecutorial considerations, in order to preserve the integrity of the administration of justice. So the commissioner should not have access to those kinds of documents, but all of the remaining documents the commissioner should have access to in order to be in a position to express a view when a requester complained that a document was put in that category as to whether or not it was genuinely in that category, and again, preserve the integrity of the system. Chapter 5 deals with the long list of statutory provisions, statutory and regulatory provisions that were set out in regulations made by the Lieutenant Governor and Council, the Cabinet, designating certain provisions of certain statutes as prevailing over the ATIPPA. So those provisions that prevented the disclosure of certain types of information in a variety of statutes and regulations prevailed over the ATIPPA and prevented the ATIPPA from permitting release of the information. The commissioner and others complained about this. Others weren't complaining about any specific act that was listed. They were complaining more about the fact that there was 24 of them that would prevent access under the ATIPPA. The commissioner felt that each of them should be reviewed with every review and should be set aside unless the head of the public body having responsibility for the legislation made a case for the continuation. Well, we didn't quite accept all of the commissioner's recommendations, but we did review every single piece of legislation there, assess the need for it to prevail over the ATIPPA, and set a standard by which that decision ought to be made. And it's all detailed. It's too detailed to go into in any detail now, but we spell it all out in the 4 separate issues that we identified. And you'll find that starting, I think, at page 137 of the report. Chapter 6 deals with personal information protection. And here we relied greatly on Ms. Stoddard, and she made a terrific contribution in this field. I should point out here that this is one of the areas where Bill 29 made some very positive contributions to the law, and we respected those contributions and provided for their continuation. And you will see that starting at page 138, and we've dealt with all of the issues. There were some political issues, or I guess 3 specific political issues that we dealt with. One was the risk to personal information of constituents of MHAs who had been asked by a constituent to make some intervention with a government agency on their behalf. And in recent years, certain ministers, if not all, had put in place a practice that required the MHAs to go through the minister's personal assistant, political assistant, and they couldn't go directly to the department. We think that this is totally unjustifiable practice. We recommend against it. We didn't recommend any legislation. If there's to be any legislation dealing with that, it's more appropriately done in the House of Assembly Act or some other piece of legislation, not the access to information. But the committee didn't hesitate to express its opinion that it was a totally unacceptable practice because it put at risk the personal information of many constituents and was essentially seen as a form of political interference. There was also concern that the Speaker raised with the committee about the potential for liability of MHAs who may inadvertently disclose a constituent's information, and there was no indemnity or no protection for them, and we recommended that that protection be put in place. The third political type thing we felt we couldn't deal with, but we just drew public attention to it. Political parties gather all kinds of personal information about individuals with a view to trying to figure out how they're going to vote and so on. This is well-known political practice, and as such, they gather quite a body of personal information. And the reality is there's no law that regulates it or protects the private personal information of individuals. And while we felt it was not appropriately provided for here, it hadn't been provided for, we felt it is a matter that should be drawn to the attention of government and the commissioner, and between them they should look at the need for developing such protection, perhaps along the lines of the BC legislation, which provides such protection. Chapter 7 is a very important chapter from the committee's point of view. It deals with the Information and Privacy Commissioner and the office that the Information and Privacy Commissioner operates. We dealt with it from several points of view, from 5 specific points of view. First, whether the oversight model should be an ombuds model or an order-making model. That is, whether the commissioner should be the type of person or the office that is an advocate for access and promotes the right of access and aids and assists as an ombudsperson the kind of access that people want to their information and the protection that they require for their personal information, or whether it should be an adjudicative model of the nature of a court that would hear the argument of the public bodies, the argument of the requester, and make an order. We've opted for the former, the ombuds model, because we think that in that means the people, the citizenry generally, will have an advocate advocating constantly for the rights to access and the right to protection of information. And based on advice, and we got a good deal of advice from the Commissioner, which we greatly appreciated. The attention that the Commissioner and Mr. Murray and their office gave to the committee was nothing short of superb, and I want to acknowledge that contribution. And in this area, they gave us frankly their views, and we considered their views and took it into account. And while there was some vacillation on their part for a while, we concluded that the first indications they gave us were the correct ones, and we should stay with the ombuds model, which is what we've recommended. And you will find those that assessment on page 195 and the 5 specific recommendations on page 210. The second aspect of it was the status and the term of office and the salary of the commissioner. And this was a matter that drew a substantial amount of criticism from the members of the public who made presentations to the committee. To quote one of them, having a 2-year term of office subject to renewal every 2 years is keeping the commissioner on a short leash, so that he will be sure to make decisions favorable to government, otherwise he's not going to be reappointed. Whether there was any truth to that or not, we didn't need to consider. But the perception of that is so obvious, and it so obviously contributes to a total lack of public confidence in the integrity of the office that approach had to change. And we recommended that it be changed, and that it be for a 6-year appointment, and that it be there be the possibility of one further 6-year term. We also were very much aware, because of these comments, of how significant the perception of the integrity of the commissioner is to the system operating properly, and that is a fact, should be a factor in the initial appointment. Presently, the House of Assembly votes and approves by a majority vote of the House of Assembly a recommendation made by the Lieutenant Governor and Council on the appointment. Well, even that, government in our system almost always has the majority members. Sometimes it's a minority government, but we're not in the practice of having that in Newfoundland. So that the perception is, if the government is going to make the proposal to the House of Assembly, the government majority in the House is going to approve it. So there's still some doubt about the integrity. To eliminate that and improve the perception of the integrity of the office, we've recommended that there be put in place a committee of senior officials of public institutions. The clerk of the House of Assembly, the clerk of the Executive Council, the chief judge of the provincial court, the president of the university, or an obviously independent body to prepare a roster of potential nominees to put forward to the Speaker. With that 4 or 5 or 6 nominees, the Speaker and the Premier and the Leader of the Opposition, the Leader of the third party, can discuss who might be best suited and the individual they would put forward to the House of Assembly, and then the House of Assembly would vote by a simple majority vote in the House. So that system should work and increase the perception of the independence of the commissioner. With respect to reappointment, or the possibility of reappointment, which is where great concern was expressed, and people expressed the view that obviously the commissioner is not in a position to make an independent decision if his future depends on how the government is going to react, how the majority members of the House are going to react to the recommendations he made. So we've suggested a solution to that would be to have a motion for extending the term for a second term of office, subject to approval by a double majority in the House. That is, a majority of the members on the government side of the House and a separately taken vote of a majority of members on the opposition side of the House. The obvious problem with that is if either one or the other is not happy, there will be no continuation, no extension of the term. Well, if that's the case, so be it. There's probably you have to assume there's good reason for the vote producing that result. In that situation, then you had to appoint afresh, and you can't run into that problem again because the vote for appointment of a new commissioner is always by a majority vote in the House of Assembly. So we feel this will address those concerns. With respect to the salary, there was equal concern of a commissioner dependent upon government to provide for regular or periodic reasonable adjustment in the salary. It would be best if it could be done independently. It hardly seems for one person to have a special process put in place to consider any potential increase in salary. So we decided it would be helpful to piggyback on one that is already in place. Judges of the provincial court, the increase in salary or adjustment in their salary is decided by an independent committee, independent of government. So we decided we should piggyback on that, and once we settled on an appropriate level of salary for the commissioner, at which we agreed would approximate the level of a senior deputy minister, then whatever percentage of a provincial court judge's salary a senior deputy minister was, that would be the percentage of the salary that would be appropriate for the commissioner. And in that way, it's totally independent of government and, again, gets rid of this bad perception. Those are some of the more significant things that we did in that regard. Then the third part of it is a discussion of the role of the commissioner with respect to, and is dealt with separately with respect to access to information, which you'll find on page 219, and separately with respect to privacy protection, which you'll find on page 233. And the recommendations as to the role of the commissioner are set out on page 243. I won't go into them in any detail now. A matter that turned out to be very significant for us and took a lot of time, and those in the media in particular who were there, and those of the citizenry who watched it on webcast, will be aware of how concerned the committee was from day one with the incredible lengths of time that were involved in many requests for information. They went on just almost interminably, and people were complaining about this. Like everybody else, we had the perception that most of these delays were caused by the public bodies, and I have to tell you that significant delays were caused by public bodies not buying into the concept of access to public information, or having other priorities in their office and being busy, or by the ATIP coordinators having other duties and not being able to give clear and immediate attention to the requests for information. So there were a variety of reasons for it, and there were lengthy delays caused by public bodies in doing it. But as a result of the questionnaire we sent out to the ATIP coordinators, our attention was drawn to some rather significant delays as a result of processes and procedures and practices in the commissioner's office. With that, having been alerted to that, we decided to do a rather more detailed checking, and we did. And you will find a good deal of assessment of the procedures and the time each one of them took, starting from the beginning right up through to August 2014. We looked at the delays in the OIPC. And I'll just quickly summarize what we found that causes great concern. On matters that were determined or decided or resolved by the informal resolution process, out of 290 that were so resolved, only 25% were completed within the time frame required by the provisions of the Act. And out of 101 matters between February 2008 and August 2014 that could not be resolved informally and were carried to an investigation, in only 5 were the reports completed within the time limit, and 43 were not completed within 1 year. That's, we found to be totally unacceptable. Clearly, when people ask for information, they want it in the time frame in which they're asking for it, or reasonably within that time frame, making reasonable allowance for the work necessary to get it and the consideration of the interest of other parties that may be involved. But getting it 3 months, 6 months, 12 months, 18 months, 24 months, 36 months later is just not acceptable. At that stage, much of the information is of no value anymore if it's not totally useless. You had to think also of the media. Now, the media have no greater rights than anybody else. Their right to access is no greater than yours or mine. But the media are an important part of our system of democratic government, and it is the media that reports to the public through the news media processes the actions and activities of government. So that when they are asking for information on a topic, they sort of want it right that day if they can get it. They realize that some of it may be such that they can't get it for a little while, and doing the story a week or 2 weeks or 3 weeks or 4 weeks or even a month later may not be too bad. But 3 years later, there's no story there anymore. It's just totally useless. So we had to change that unacceptable system, and we've made detailed recommendations, and you'll find those on page 257 for a change. There were a number of factors that caused it, and you'll find in the report an expression of the committee's view that it has no basis whatsoever for thinking, suggesting, or even thinking or contemplating that the Commissioner's Office was doing this deliberately to cause delay, or the Commissioner's Office, we are confident, were acting in good faith to try and get as much information out as possible. It's just that the practices and procedures they thought were necessary were the wrong ones. Under the existing legislation, it's not the decision of the Commissioner that a court on appeal looks at, it's the decision of the public body. So the Commissioner doesn't need to do this detailed examination and write a Court of Appeal type judgment as to the pros and cons of this and what a commissioner in some other jurisdiction did or a court somewhere else said on the issue. That's for the courts to do. The Commissioner is there to facilitate access at the quickest possible time with the lowest reasonable cost for those who are accessing it. And these are the recommendations that we made for the Commissioner to change the approaches of that office. The fifth and final part of this chapter is the existing time limits and extensions and compliance by both the OIPC and public bodies. And you will find set out on page 272 are recommendations that spells out in detail exactly how the system should work. There are 3 or 4 pages of it, and it goes through it in clear, succinct detail, and it should make it very clear. A final thing that we put into that is when the commissioner makes a recommendation, if a requester asks for a particular piece of information, the public body considers it and says no. The requester goes to the commissioner looks at it and says, we recommend you do it. Instead of the individual then having to contemplate the cost and difficulty and delay of going to court to appeal that, what we've put in place is a requirement that the public body has 2 options. The public body either immediately adopts and acts on the commissioner's recommendation and releases it, even though they had earlier decided not to, or the public body makes the application to court for a declaration that they are not required by law to do as the commissioner recommends. So the emphasis is on, and the burden is on the public body. And when you stop to think about it, very obviously that should be the case for this simple reason. We operate on the assumption that the information held by all these public bodies are publicly owned information to which we're all entitled to access. We agree that there are certain limitations that the law clearly provides for and should provide for. And if a public body is going to say, no, I think the law permits me to say no, then it's the public body that should have to make the case for protecting it, not the individual having to make the case to release it. And that's what our process does, and sets in place strict time limits that requires it. The other thing that we did there is, it's been known to happen in the past that even though the law specifies that a public body shall do one thing or another, sometimes public bodies don't always do that. And it's not very easy to provide for a penalty or a matter of compulsion. So what we've provided in that regard is that unless the public body either grants the access recommended by the commissioner or applies to the court for a declaration that it's not required by law to do so, unless the public body does one or other of those things, then within 15 days after making his recommendation, the commissioner can write out a summary of the order that he made and file it in the registry of the Supreme Court, and it becomes an order of the court. So the public bodies can't thwart or frustrate.
Would that then compel the release?
That would compel the release.
That would compel the release?
It's an order of the court, enforceable. Unless, of course, there's an appeal of the order. It's an order of the court and it's subject to appeal. But then the public body is compelled to act and the court is supervising. The eighth chapter deals with municipalities, which caused a surprising amount of concern. It was surprising to the committee that there was the level of concern. And what we discovered was that most municipalities, and you realize most municipalities in Newfoundland are small municipalities. They don't have a big staff. They don't have ready access to lawyers and advisors on legislation and so on. And they're expected to conform to normal principles of municipal law, of transparency for their citizenry in all of the decisions that they make, and so on. And then they get bombarded with advice that be careful about releasing information. You may be breaching personal privacy and you will be found liable in damages. So everybody is terror-stricken about releasing private information, so much so that we found in some municipalities they were blacking out the names of applicants for permits and blacking out certain other information that was considered personal information. And some councillors complained to us that they went into the council, at least one councillor complained to us that he went into the council seeing this and not having information on which he could make an intelligent decision in the best interest of the municipality. So that was a cause for concern, and I must say the OPE acted immediately on this and put in place a process to make to give advice and better guidance to municipalities fairly quickly. But we still feel, the committee still felt that the approach taken by the OPE and the Department of Municipal and Intergovernmental Affairs was not adequate. They weren't giving proper level of priority to the importance of transparency in municipal decision-making. So we've recommended that they put in place an amendment to the Municipalities Act, probably to Section 215, to expand and elaborate on the information that municipalities should make available in the public interest and provide for that overriding the requirements of the ATIPPA. And in that way, they could make intelligent decisions without concern. The extreme case we found was one suggestion where the municipal officials had crossed out all the names on a petition that was submitted. A bit extreme, but it demonstrates the concern that the municipalities had. You'll find that recommendation on page 287. On Chapter 9 is an assessment of those requests that we had for particular exceptions. The Veterinary Medical Association, the CONA, and Memorial, and one or two others had requested exceptions. And essentially, the committee did not agree that any of them should be granted. And I should note here that you will find at the beginning of the report a notation that because of the fact that the law firm with which I'm associated has acted for both Memorial and College of the North Atlantic, the decisions respecting their requests were made by Mr. Leto and Ms. Stoddard, and not by me. The final one is Chapter 11, and it deals with just a variety of non-controversial statutory recommendations being made by the Commissioner and how the committee dealt with them. Chapter 12 is the recommended statutory changes. The committee had come to the conclusion fairly quickly that because the changes that we were making would be so extensive that it would be difficult and would make the report very difficult to read and understand if we just simply recommended that Section 81 be changed to read this instead of that. And it would be just utter confusion. So we thought the best way we could make a comprehensive proposal is to draft a bill for presentation that would incorporate all of the recommendations that the committee was making. And that's what we did, and you'll find that attached to Recommendation 90. Now, I think that that's enough for me, unless you want me to say something else.
I'll make a few closing comments before we open the floor to questions. And Mr. Wells, I want to thank you for what was a very comprehensive overview. I don't think anybody could argue otherwise. The detail provided, along with such complete analysis, is a testament to both the process utilized by the committee and the careful consideration of all issues brought forward by key stakeholders, public bodies, and the general public. I want to thank everybody who participated in the review process, and again, the entire review committee for their work and their incredible dedication. So now we get moving. As committed by the Premier, we get moving to the implementation phase of these recommendations. It's important to remember that some of these changes that we are looking at are far-reaching, and they have impacts across government, outside government in the Office of the Information and Privacy Commissioner, and even on other pieces of legislation. From the government's perspective, there are two main focuses for action. The first being the relevant legislative changes coming out of the recommendations of the report. The committee has provided us with draft legislation, as Mr. Wells just outlined, which will be prepared for introduction in the House of Assembly as soon as possible. The majority of recommendations fall in this category, and we are looking forward to introducing a bill in the spring session that will allow for a new legislative framework that would see this province become a leader in access and privacy legislation internationally. The second focus is on those recommendations that are not directly tied to legislative change and include procedural or policy changes. Government will begin immediately to develop an implementation plan for these recommendations, taking into consideration the associated financial, human resource, and procedural impacts. So some of the key focus areas, just as examples, include an online application and payment system, the role of the ATIPPA coordinator, ministerial briefing books and how they're handled, proactive release of documents, protection of personal information in emergencies, helping ensure transparency and accountability at the municipal level while also protecting privacy, providing support and guidance to municipalities in conforming with ATIPPA, supporting consistency in the performance of information management systems in public bodies, working with applicants so that data sets and other machine-readable records can be understood and full use can be made of them, and further defining the mandate of the 5-year statutory review process. Democracy requires citizen involvement. We want to become a world leader in engaging citizens, providing the information needed to make decisions, and creating the best governance possible based on dialogue. I have every confidence that this review and its recommendations will provide residents with the strongest possible framework in access to information and protection of privacy. I want to thank Mr. Wells and Mr. Leto and Ms. Stoddard once again for their excellent work. And I want to thank those in the room who've joined us today. And I look forward to seeing many of you on my favorite day of the year, St. Patrick's Day, in the House of Assembly.